Hello, I'm Tim Larson. I'm a partner here at Larson & Brown. We're an estate planning, estate administration law firm, and we work with people who are going through those issues. I'm going to be explaining here trust administration, which is a provision or article that we use in our revocable living trusts. And in a joint trust, this is typically Article 14. If it is an individual trust, it is an earlier article, such as Article 11, but in both cases, the article is virtually the same. This is the article in your trust that explains all kinds of various situations, how things should work with the trust. For example, in the first section, it says distributions to beneficiaries, and it explains that distributions can be made in cash or in kind, and that means assets can be distributed. Everything does not have to be liquidated. For example, if one child wants and desires to have the family home that the parents had, that can be distributed to that child as part of that child's share. And we can have language in the trust that will explain whether or not, if it's more than what their share should be, how we handle the financing of that, or if it's less, then to adjust other things for the value of the property. But in any event, those distributions can be made in cash or in kind. Everything does not have to be turned liquid to cash in order to distribute the assets in a trust. If we have investment assets, for example, if there are 3 trust shares for children, we can set up an account at the same place where at the financial advisor's business, where we set up accounts for those 3 trust shares and then just distribute those interests, whether they're in stocks, bonds, mutual funds, straight to those trust shares, and not change the way the assets are invested, leave them invested as they were before the individual's death, and just transfer those to those shares. We're not going to liquidate them typically. But as I said, this article has many provisions that go through specific situations and explain various things. This is the part of the trust that can be pretty boring to go through, but I tell people if they look at each section and really read what's there, they can tell that it's important that it has been included. There are things such as saying that a trustee is entitled to reasonable compensation, and we can talk through how that can be determined and proposed. There's authority to employ professionals such as accountants or attorneys or other people that might need to be used by whoever's serving as trustee. How different processes should take place during the administration of the trust. There's quite a bit of language relating to accounting issues, which are very straightforward on both accounting and taxes, so that to the extent possible, you pay the least amount of tax that can be paid. And then there's a section or two that relates to information to beneficiaries, and we typically provide that privacy is important to you, that nothing should be revealed or leased to anyone who doesn't have a right to it, and that, for your beneficiaries, typically they don't need to have any information about your assets while you're living. When accountings and information do have to be provided, there are provisions that spell out how to do that so that the beneficiary is just receiving what they need to know and not other information. The trustee has the authority to carry out the administration of the trust. They can do many things. They've got a broad range of control over assets and what can be invested. They have the authority to take care of administrative matters that need to be dealt with, such as if there's been a death of a beneficiary, to then change how property is distributed according to the terms of the trust. And there's a provision even to have authority to terminate a trust. Kansas law says that if a trust or trust share has less than $100,000 in value, that it's the trustee's discretion whether or not to continue that trust. And sometimes it may not be, but other times if we have reasons for asset protection or because somebody's receiving governmental benefits, we want to make sure that those trusts continue even if they have less than $100,000 in value in them. And there's also authority to take care of a funeral cost for a beneficiary, to do what makes sense. And we also provide that we want to make sure that the assets that go over to the surviving spouse are completely qualified for what we refer to as the unlimited marital deduction. And that's Article 14 on trust administration. Give us a call if you have questions at 316-729-0100, or you can take a look at our website and maybe gather more information there. Just check out larsonandbrown.law.